You're in a case. You have a difficult opponent. The guy's been driving you nuts. Matter of fact, he was maybe the attorney who was at that deposition on the clip Mary Jo showed earlier. You have a motion to file. It's a marginal motion for summary judgment on one of the claims that they have filed. Marginal. Yet, it would further your client's interest. Is it civil? Is it professional to file that motion? Anyone? Is it the right thing to do?
Sure.
Why? Who said that? You did.
No.
I almost picked on your colleague. You did.
If it's valid legally and it's backed up by fact, and you have, all cases are made up of little points. If one of them can be resolved without having it to go through litigation, just be decided by the judge, you've actually saved time. But if you're just doing it to yank the other guy's chain, probably not.
That is about as good of analysis of that question, the appropriate answer, as I've heard, having done this program several times. Let's say that same attorney calls you up and says, I would ask that you stipulate to the following facts. Now, can you stipulate to them? You probably can. They're really not in dispute. But as a plaintiff, they have the burden of proof, and you decide this guy has so annoyed you that you're not going to agree to those stipulations. You're going to make him spend the time, spend the money to litigate those points and to make sure those points are proven. Now, can you do it? Just like Bob the Builder. How many people have little kids? Like Bob the Builder says, yes, you can. Should you do it? Anyone? You said no. You said no. Why did you say no, good sir?
You shouldn't let your personal animosity towards the guy influence your professional decision.
Right, and that relates back to a couple things. Not only your integrity as an attorney, but let's say that difficult adversary files a motion before the court or asks for a conference before the court, and you're before his honor. And you say, Judge, I probably could have stipulated to those, but you realize what a jerk this guy has been throughout the course of litigation? Your response, Your Honor?
My response is kind of a long story. And that is this. A fellow by the name of Mortimer Leviton wrote back in 1957. He says, the secret ambition of every brief is to spare the judge any necessity to do any work. Meaning that when you write that brief, make it as clear as a bell. What did Denzel Washington say in the movie Philadelphia? Explain it to me like I'm 5 years old. Okay. Because I've got 1,200 cases on my docket, in a civil docket. And everybody wants to file that little marginal motion for summary judgment. And they want to attach attachments that are high. And if the lawyers don't want to stipulate to something like the simple facts of the case, then they come into court and they want to argue about the simple facts of the case. I just had a case, I just concluded a case on Friday. The question was, this cabinet maker who fell through a floor in a 10,000 square foot big old house out in the desert under construction. The question was there a hole in the floor or was there not a hole? How did he fall? 2 weeks to figure out, was there a hole in the floor or not? I prefer to stipulate something.
So again, underlining these points, the points Mary Jo made, the points David made, think in terms of the rules of professional conduct as that which we must do, and civility as being that which we should do. Why state the obvious? You're all sitting out there going, why did Al Lama make us come to this building on an early Monday morning to listen to a guy from New Jersey and a guy from New York talk about civility? Neither state's strong suit, by the way. Well, the answer again, it goes back not only to the trust in the litigant, it also goes back to the trust in our office. We appear as an office, you appear as an office, before every forum in this state. How your colleague over there may conduct herself in a particular forum may affect her colleague over here in that same forum a week, a month, or even a year later. As the judge alluded to, judges talk among themselves. I hate to break that to you, they do compare notes. and they will compare notes and go, have you noticed how the Attorney General's office has come in here repeatedly before you and engaged in conduct that was less than what we would consider appropriate or civil? And that may be done based upon the actions or inactions of just one person. Not only those who are attorneys, but those of you who are paralegals, administrative assistants, or investigators who may accompany the attorney into court. That which the attorney cannot do does not mean you can. In other words, insulting the other side, tripping them as they go into the elevator. Not that any of you would ever do something like that. Accosting someone in the vestibule like you saw in Mary Jo's video. Just because your attorney can't do it, it's bound by the rules of professional conduct. Folks, that applies to you. While you are not directly regulated by the rules of professional conduct, derivatively, your conduct can be attributed to that trial attorney, to Al as first deputy, and certainly to your attorney general. I do not think you want to go into your attorney general and say, yeah, I got into a shoving match in the vestibule outside court, but I really had a good position on the argument, and I thought I could take the guy. And you want to avoid that. And you know, if you don't want to take my word for it, Mary Jo alluded to a quote by Justice Kennedy earlier, which I think is an incredible quote. And also Judge Risa Hawkins Barksdale, who was in the Fifth Circuit, is now in senior status, who said civility is the mark of a true lawyer, a true professional. On your career epitaph, if that's what they write, that's pretty good. I was going to say something. That's pretty darn good, isn't it? I mean, I would rather have that than he knocked out 15 of 20 adversaries during the course of his career. Not a good thing.
Yeah. The junkyard dog is always remembered. He's usually, or she's usually remembered as the one that's not professional. And again, it carries forward no matter where we go. Why is that important to you? We talked in the first segment about being effective. Okay? We talked about being effective. Al talked about being effective. If the judge is not going to give you the benefit of the doubt when you need the benefit of the doubt, particularly when attorney generals are coming to my court, we're always talking about policy. I've got this case right now that involves fish pedicures. You ever read about that? Fish pedicures. Right? The question is whether the regulation of fish pedicures by our cosmetology department is constitutional or unconstitutional. Total policy, right? Or whether it's arbitrary and capricious the way they've been regulated. Assume for the moment that the Attorney General that's in front of me has been a bad actor for a long period of time, and I can't believe why, perhaps I cannot believe why, their explanation as to why they want to ban this makes sense. Because they were such a bad actor before. That puts you and your agency wrong. On the other hand, the other side has been bad actors over the years. And maybe I want to give the state the benefit of the doubt. Because remember, judges are human. And we have to give the benefits of the doubt as well, because I challenge you to find a case that's going to help me decide that. Don't want to decide that. Except in Thailand, where they do this on a regular basis.
And it is constitutional in Thailand. So if you're looking for them, that's the place to go. Again, the reason we state the obvious is we are now going to go quickly through a series of cases that we have sampled throughout the country where behavior has led to either reprimand, suspension, or in several cases, disbarment. Okay, in this case, not a good thing to call the judge you're appearing before a crook. Not necessarily the smartest thing to do, and especially referring to him by his first name, Frank the Crook. This case arose out of a situation where the attorney, the offending attorney, had been relieved as counsel. Superseding counsel got a huge attorney's fee award. In the supplemental proceeding by this attorney as to why he was entitled to some of that award, these are some of the quotes that came out of his mouth. Now, he did try to assert that the trial court was in Chicago, and hence crooks and fixing things should have been a defense, as it was the truth. That did not carry the day with the judge. And this attorney was actually disbarred for this conduct. Not only for attacking the integrity of the judge, but attacking the integrity of the system as a whole.